Just to make sure I put this disclaimer on here, I am not a lawyer, and even if I was a lawyer, I would not be your lawyer. So please do your own research. This is just a very high level review of what protections you have and what you can kind of expect under your Fourth Amendment rights. So if you're going to be out in large groups, stay safe out there.
Okay, so I had to get my nerd glasses on because we need to start talking about some serious stuff, which I'm going to start with our individual rights that are enshrined in our Constitution, because hopefully we can save our Constitution. It's the longest living Constitution in the world right now. It is definitely under attack. But if we can't save it, at least there will be documentation that at one time we did have individual rights enshrined in the Constitution. So I am going to start with the Fourth Amendment, which is our rights against illegal search and seizure, and also it's where your privacy protections stem from, um, because that's probably one of the first rights that they will come after. So the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
So I just want to do a quick reminder of why we have the Fourth Amendment. And it's because under the rule of King George in the colonial times, the king's soldiers carried what was called a writ of general assistance. And it meant that they could search anybody in any place they wanted to without suspicion that a crime had been committed, without suspicion that a specific person was engaged in criminal activity. But literally, if you spoke out against the crown, if you protested, they could use it to stop you and completely search you, or come into your home and ransack your home and just drum up any evidence that could be indicating criminal activity, and then they could charge you with a crime based on anything that they found. So the reason we have the Fourth Amendment was to require law enforcement to have reasonable suspicion of criminal activity before they could get permission to come into the most private area of your life, your house or your body, and search for evidence.
So, just right off the top of the bat, number one, you cannot be searched without a warrant unless an exception applies. So, there are multiple exceptions that have been um, basically implemented through different Supreme Court cases throughout the years. So I'll go over those as well. But you cannot be searched without a warrant. You cannot be seized without a warrant unless one of the very specific exceptions applies. So your house is highly protected. Your house is considered sacred. Your person is considered sacred. So you have the highest privacy protections in your house and your person. And then you also have privacy protections in your car, but not as high level as you have in your house and your person. And then the whole warrant situation, in order to get a warrant for a warrant to be valid, the warrant has to be supported by probable cause, and the um, agent or the entity, the state actor who is seeking the warrant, they have to describe in the warrant application what the probable cause is. Then they also have to support it with oath or affirmation, where they are basically affirming that they're telling the truth. And then the warrant also has to specifically describe what they are looking for or who they are looking for. So, for example, let's say that they are coming into a house with a warrant and they are looking for a large assault rifle because the person suspect is suspected of a shooting with a large assault rifle. If they say we're looking for a large assault rifle, They cannot look in drawers that are smaller than what the assault rifle would fit in. Okay, so if they're coming at you with a warrant, read it very carefully to see what it says they're looking for, because what they put in that warrant may restrict where they can and cannot look in your house or on your person. So, a few of the exceptions for the warrant requirement. Number one, the plain view doctrine. Evidence or contraband that is in plain view, and the officer or the state actor that sees it, if they are lawfully or legally in the position where they are standing to be able to see it, and they have lawful access to it, they can take it and use it as evidence. So you want to make sure that you're not leaving things laying out in the open, whether that be out of the property around your house or on the seat of your car. They cannot move things or manipulate things to get a better view or to uncover things. So they can't manipulate or move things. But if something's in plain view, they have legal access to use it as evidence. There's the exigent circumstances exception. This, a lot of times you'll hear it called the hot pursuit exception. So if law enforcement is pursuing a fleeing suspect and that suspect goes into a home, they can then go into the home to apprehend that suspect. You also would find this in immediate danger situations. So if there's a fight, somebody's in danger of being harmed, or law enforcement is called to do a welfare check, those kind of situations, they can go into a house or an apartment, hotel room to check that out to stop somebody from being immediately harmed. Once the exigent circumstance is over, they have to retreat and get a warrant to return and do any further searching. The last one for exigent circumstances is to prevent the destruction of evidence. So a common example of this would be law enforcement, out in a hallway, ready to do a search, or maybe just ready to knock on a door and ask some questions, and they hear sounds inside that are indicative of evidence being disposed or destroyed. So, like toilets flushing would be a common example. Another one is consent. This one is really important for people to understand. Your consent, if you say, yeah, sure, go ahead and search me, search my bag, search my car, search my house, if that is completely voluntary, anything they find is fair game. Now, you can give consent and you can withdraw consent at any time. So you can all of a sudden say, you know what, no, I'm not comfortable with this anymore, so this is over, my consent's withdrawn. Law enforcement does not have to tell you that you have the right to refuse. So if they're asking you to search your bag or something, they don't have to tell you that you have the right to refuse. You have to know that you have the right to refuse, that you don't have to give your consent. Landlords cannot give consent for your rented property to be searched unless there's language in your contract that allowed the landlord to maintain some possessory or occupancy rights. Your landlord cannot consent for your private space to be searched. If you live with roommates or a spouse or partner, consent gets a little tricky. A roommate can give consent for shared spaces and their private spaces to be searched, but they cannot give consent for your private spaces. Let's say you have your private bedroom, your private bathroom, maybe you have a private office in the apartment or home. If they are your spaces and you are the one who used them, your roommate cannot give consent for those to be searched. The consent would not be valid. Unless law enforcement can prove that they thought your roommate had authority over the space. Your partner or spouse, they can give consent for search, and if you share all of your spaces with them, they can give consent for the entirety of the dwelling. So you want to make sure that you're communicating with your spouse or partner. Now, if you're both present and one says no and one says yes, the no stands. But if only one person is present and they say yes, then consent is valid. And then lastly, a hotel clerk, owner, housekeeping, they cannot give consent for your room to be searched unless you have abandoned the room. So let's say maybe you were supposed to check out, but you didn't check out, and all your stuff is still there, but you haven't paid the bill yet. Um, they can give consent for that room to be searched because you have overstayed your agreed upon duration and you no longer have the authority over that room. So make sure that you are communicating with a hotel front desk if you're extending your stay, so that they don't think that you just failed to check out and abandoned your property in that room. The automobile exception is a big one. Um, Law enforcement here, they've got to have probable cause that the car contains contraband or evidence of a crime. So, but this can be done if the car is parked on the street or if you get pulled over. They can search the entire vehicle, and they also can search containers inside the vehicle. So that means purses, backpacks, suitcase, laptop bags, pill bottles. It depends on what they're looking for. If they're looking for something large, let's say they're looking for an assault rifle that they suspect the person that had the car committed this crime with an assault rifle and they think it's in there, then they're not going to be able to look in, pill bottles and purses and backpacks because they know they're looking for something larger than would fit in those types of containers. But if somebody saw drugs being put into the vehicle and they have probable cause that the drugs are in that vehicle, then they can search any container in the vehicle that's small enough to hold whatever their probable cause says is in that vehicle. So it does not matter if the container belongs to the owner of the car, the driver of the car, or a passenger of the car. If it's in the car, it can be searched. The next one is a search incident to a lawful arrest. So if you get arrested, you are getting searched. They can search you and they can search the immediate area around you. What that means is if you were in the car right before you got arrested, they can search the passenger compartment of the car, and that would be for contraband or weapons. If you were at home, they can search the room that you were in, uh, and that is the extent of it, unless they think that there may be like a third person or other people in the house that could be dangerous. Then they can do a protective sweep of the house. But once they do a protective sweep of the house and determine that there isn't anybody there that's a danger to them, then that search has to end. And if they don't have a search of the house in the warrant that they came to arrest you with, they have to go get a warrant to search the house. And they have to have all of the particularity items that are required for a warrant. So that's the particular place and the particular items that they're looking for. All right, now I want to cover the different types of encounters that you may come across with law enforcement officers. So, number one, there's the consensual encounter. This is a casual encounter. It's voluntary on the part of the person being stopped. So that would be the citizen. And it's an interaction between a person and a law enforcement officer where the person is free to leave at any time. Now, the officer does not have to tell you that you are free to leave at any time, but the officer also does not have to have any suspicion of criminal activity or that, you've been involved in criminal activity. They can literally do this to anybody. Stop, ask you questions. Now, you do not have to give them your name. You do not have to give them your ID, and you do not have to answer questions. You can tell them, I'm not comfortable talking to you. Since they don't have to tell you that you have the right to leave, if you're not comfortable and you want to walk away, you can literally ask them, hey, am I free to leave? If they say yes, you can walk away. If they say no, this is not a consensual encounter. And if it's not a consensual encounter, then they need to have at least a reasonable suspicion to be talking to you. So the next step up is called a Terry stop. And this is a brief investigatory conversation. And in order to initiate this, the officer has to have reasonable suspicion that you either just committed a crime or were involved in criminal activity or you're just about to. And so they have to be able to articulate, they have to be able to describe in words why they thought that you either were recently or about to be involved in criminal activity. Now, if they engage in this Terry stop with you, you do have to tell them your name. You do not have to answer questions. But if they believe that you might be armed and dangerous, they can do a frisk, a Terry frisk, which is kind of a pat down for weapons. Now, if they feel something else, like let's say you've got contraband in a pocket, if they know without pulling it out and looking at it that it's contraband, they then can search you. But this is not a general search for evidence. It is all about officer safety. So it has to be initiated based on their premise that they believe that you have a weapon and can be armed and dangerous. You really want to keep your wits about you when you are engaged in any of these types of encounters. So if you are approached as a consensual encounter, remember, ask, am I free to leave? If they say no, then you are now technically seized. And if they then put you in handcuffs, transport you to the station, you are definitely in custody at this point. If they haven't given you formal charges or said you're under arrest, you're not under arrest yet, but you are in custody. So you are entitled to your Miranda rights, but they do not have to give them to you until they are ready to interrogate you. So they can put you in custody, transport you to the station, put you in a room, leave you on a bench in the hallway, and leave you there for a while, kind of wondering what's going on, stewing, maybe getting hungry, maybe wondering if your family knows where you are. But anything that you say during that entire encounter is available to them to use to further their investigation, use it against you as evidence, use it to identify other people. So you want to make sure that you're not kind of giving anything away while they are making you sit there and wonder what's going on. So you definitely need to keep your head on straight and keep your wits about you. Once they want to start an interrogation, they have to give you your Miranda rights, and at that point, you have the right to an attorney, and you have the right to remain silent the whole time. So, there have been some other videos on TikTok that just say "shut the f up." In this day and age, with who knows what's going to happen, if you are in custody, if you're in a casual encounter or a consensual encounter, name, and that's it. You do not have to answer, and am I free to leave? And if they say yes, get out. Just go home. There's another protection that you have around your home. It kind of cuts the middle between the searching in your house and the plain view doctrine, where law enforcement can basically have access to anything they can see from a lawful position with lawful access. But this is called the curtilage doctrine, and this gives you a little bit of protection in the area outside and around your home. So in order to have curtilage protection, the court will look at a few different factors to determine whether or not the area or the activity should be protected, and that is how close it is to the house, whether or not it's enclosed with the same fence as the house, what kind of activity is going on in the area, and then any measures that you take to keep the area private. And this case came out law enforcement going through a property fence onto a property where there was a house with a fence around it, and then there was a barn about 50 yards away. And the officers could smell chemicals that were involved in drug making coming from this barn. I think the door was open. And so the homeowner, property owner, tried to use the Fourth Amendment to say, this was an illegal search. And the court said, no, it wasn't, because the barn was outside of the fence that contained the home. It was 50 yards away from the home. You had drug making activity go on there, which is not intimate activities of family in the home. And I think the door was left kind of wide open so the officers could see in. So even though the officers had gone past no trespassing signs on the outer kind of property fencing, um, the barn or what was going on in the barn was not protected under the Fourth Amendment. So you do have to think about what are you doing on your property but outside of your home, and how are you trying to protect yourself there. So, for example, for me, my garage, I have a home gym. I've got a TV mounted on the wall. I've got a freezer. At one time, I had a microwave out there, and I've got some chairs out there. So it's obvious that that space is used for family activities or home activities, and so um, that would be protected as part of my home, or it should be under the current doctrine. Another protection that you have is law enforcement cannot use technology to see inside your protected spaces. So some of the cases for this was, I believe, Kylo, where law enforcement used heat imaging or thermal imaging device to see the heat signature on a dwelling, and it showed a heat signature that was consistent with a grow operation. And in that court case, the judge actually said, this is invasion of the privacies of life of the home, because you could have seen the woman of the house taking her nightly bath and been able to know what temperature her bath water was or something like that. And then there was another case, Jardines, where law enforcement took a drug dog up onto a porch of a home and let the drug dog kind of sniff around, and the drug dog then alerted, and so they searched the home, and there were drugs in the home. And the court decided in that case that a drug dog is, a specialized tool, and then the porch is also protected, kind of like that curtilage doctrine. And taking the drug dog onto the porch and then staying longer than a general invitee, which a general invitee would be like your postman delivering your mail, or a door-to-door salesman knocking on your door and you saying, hey, you know what, no thanks. So the law enforcement officer stayed longer than that. And I think they even talked about, Girl Scout cookies, coming to the porch to sell cookies and be turned away. So if the law enforcement officer stayed longer than that, then they exceeded their welcome as a general invitee. They exceeded the kind of reasonable amount of time that they should have been there. And so that evidence was also thrown out. The alerting of the drug dog was considered an unlawful search. So law enforcement is not allowed to use technology that is not in general use, out in society. And then they're not allowed to use technology that can see and detect things that would only otherwise be observable from entering the home. So who knows, with the way things are going, and maybe an increasing police state, those things may change, but that is the law currently. Probably the most important thing to talk about is your cell phone. Advancing technology, the ability to geofence and read data off of your phone if you pass inside of a digital boundary that you can't see that law enforcement has set up, that definitely causes some concerns for the invasion of privacy and your protection against unlawful search and seizure. So I just want to tell you a short story. I've got it kind of on my screen over here, so I apologize if I'm reading a little too much. But basically, in 2023, the Iowa Department of Criminal Investigations, it might have started in 2022, like late 2022, but what an investigator with the Department of Criminal Investigations, without a warrant, without even, I believe, informing his supervisor of what he was doing, he decided that he was going to run his own personal sting operation, and he was going to go to the University of Iowa and set up geofencing equipment around freshmen and maybe sophomore dorms. And he wanted to catch underage gamblers. Now, underage gambling is in the Iowa Code. And there's also language in the Iowa Code about preventing people who aren't supposed to gamble. So that also includes like NCAA student athletes. But the actual owners of the sports books apps in the Iowa Code were the ones who were responsible for making sure that people who weren't supposed to use their apps weren't using their apps. So this DCI investigator, all on his own, decides to set up this sting operation, and he finds that there are a lot of phones inside this geofence that are on these sports betting apps, but there isn't really a way to tell if these people are underage or not. So then he gets a better idea, and he decides to go and set his geofence equipment up around the athletic facilities. And so he went and he set it up around the athletic facilities, and he was able to see a lot of phones were on the sports betting apps inside these athletic facilities. One of the other key factors here is that he had no evidence of previous illegal activity, so he had no reasonable suspicion or probable cause. He just decided on a whim that he wanted to go on a fishing expedition, which, if you remember from the reason that we have the Fourth Amendment to begin with, was to prevent King George's soldiers from going on fishing expeditions and digging into our lives and our homes and our personal effects and our property to find evidence of a crime before there was any suspicion of a crime. So, according to early reports back in the spring of 2024, fall of 2023, it was reported that he actually did at one point go to his supervisor and say, "Hey, guess what I did?" And his supervisor said, "Hey, you need to shut that down." And he didn't. He went and did it again. And then he went back to his supervisor and said, "Hey, now I've found all these athletes, these phones that are on these sports betting apps at the athletic facilities. So we know that these are definitely people that aren't supposed to be on the sports betting apps." At that point, his supervisor then got on board with him, and they got a subpoena for software from like the sports betting app developers, I think, or the sports betting app owners, and they got this software via a subpoena in order to read all of the data on the phones in the sports betting apps that were inside these geofences. So eventually, the software developer found out what they were doing with it and cut off their access to the software and said, "You have gone outside the bounds of what we agreed to the scope of your use of the software." So they cut off access to the software for the Department of Criminal Investigations. By that time, it was too late. They had already gotten the data, the identifying data off of the apps that had been active inside those geofences, and they used it to file criminal charges against some of the student athletes. From what I read early on in the case, it was that maybe they weren't old enough and they were using like their parents' account to make their bets, but they were using somebody else's account to make their bets. So they initially got charged with like some kind of identity theft type of crime. And then many of the student athletes were actually old enough to be using the sports betting apps. So they weren't able to be charged with identity theft because they used their own accounts, and they weren't able to be charged with underage gambling. But then those student athletes were turned over to the NCAAs, and they were penalized by the NCAAs. And so many of them lost their eligibility for the year. Some of them lost their senior year of eligibility to compete in their sport. Now, a few of these student athletes were brave, and they decided to fight this, and they got a lawyer. And the criminal defense lawyer that tried to represent these kids basically was given the runaround by the state. The state would not release information about, how they got the data or how they were able to identify the people who were using these apps. And so the defense attorney actually had to use what's called an investigative subpoena. And what that is it is a type of subpoena that a defense attorney can serve on the government entity who is prosecuting a crime against their client. And it basically makes the court force the state or the prosecuting attorney to turn over evidence. So this whole time, the state was refusing to turn over the evidence of how they got the information to begin with. And once those were granted, then the floodgates opened, and now all of a sudden it was very obvious that all of this was done without a warrant. They jumped from a whim with no reasonable suspicion all the way to collecting intimate data off of these kids' phones and right to criminal charges. And so the next big cover up for all of this is that when all of this started to come out back in late January, February of 2024, the state of Iowa, the Republican legislators, and the DCI and their lobby group, they all of a sudden introduced a whole bunch of rule changes for the Iowa court rules, and one of them was to get rid of the investigative subpoena. And it has been well documented in the news and via the lawsuits now that have been filed in federal court for the violation of these kids' privacy rights and civil rights and constitutional rights, that the whole point for trying to change the court rules to get rid of these investigative subpoenas was because if the defense attorney had not had the ability to use the investigative subpoena, he never would have gotten the evidence or the information, and these kids would have ended up either pleading guilty or going to trial and possibly being convicted of these criminal charges when all of the evidence was gathered in complete violation of their constitutional rights. So we are watching in real time the state of Iowa being turned into a police state. The Supreme Court has basically given us the utmost privacy protections in our cell phones. They have acknowledged that you can hardly function in today's society without a cell phone. They've acknowledged that people carry them everywhere. You know, they're with us 24/7. Therefore, they would give away our location 24/7. And the Supreme Court decided in the Jones case in 2012 that people have the expectation of privacy in their constant location data. Um, and also, again, in Carpenter in 2018, they said, you know, cell phone companies cannot give out their customers' cell phone location tracking data without a warrant. Because even though what you do in public is not protected, your every single move of being tracked from one place to the next 24/7 for like cell phone companies keep that data up to the last 5 years. They said, no, you have an expectation of privacy in your location as a whole of, you know, where you travel to or from every minute of the day because your cell phone literally tracks you every minute of the day. So the Supreme Court has said that we have the utmost privacy protections in our phones, and they do contain the privacies of life. I mean, we have people that have period trackers on their phone now, which if you do, I would 100% take it off of your phone. But with the advancement of technology, the ability of geofences to be erected, and in order for data to be read off of your phone when you cross into these boundaries that you can't even see, you know, you should have an expectation of privacy in your phone in your pocket when you can't even see that you're crossing into a boundary. I mean, if there was a big sign that said, you know, geofence boundary, your phone data can be read if you walk inside of here, then, you know, you're on notice and maybe that is on you, but you can't see a geofence boundary. So the fact that law enforcement would use these geofence boundaries without a warrant and without any information of a crime having been committed is a complete invasion of privacy.